What is a non-testimonial statement when dealing with the Confrontation Clause? I'm plus Attorney James Wirth, and that's the topic that we're dealing with today. Inspiration for this video comes from a case that came out today from the Oklahoma Court of Criminal Appeals, M 2022-174. And although it's not a published case, it's interesting because it has two issues in it relating to potential violations of the Confrontation Clause that gets in that into that issue in somewhat detail. But for the purposes of this video, it's about what is non-testimonial statement. So you have the right to confront your witnesses in court, under the Confrontation Clause of the U.S. Constitution. But case law from the United States Supreme Court has said not every statement is required to be, gives you the opportunity to have confrontation. It has to be a testimonial statement for you to be entitled to confrontation. So this case deals with domestic violence situation where the person claiming to be a victim of domestic violence did not testify at trial, and the state got in hearsay statements from that person, and they're complaining, hey, I wasn't given the opportunity to cross-examine them. I was denied my right for confrontation. And the court had to determine, was that right violated? And in order to do that, we've got to look at the test. And what the test provides, and this is from Crawford v. Washington, the United States Supreme Court case, it says, the Sixth Amendment right to confrontation bars the admission of testimonial statements of a witness who did not appear at trial unless he was unavailable and there's a prior opportunity to cross-examine. So it has to be testimonial statements. So what is a testimonial statement? What is a non-testimonial statement? Well, in the court in a subsequent matter, Davis v. Washington, another United States Supreme Court case, got into the details of when it is testimonial and when it is not testimonial. And when it is not testimonial is when it's an ongoing emergency. So were these statements made as part of an ongoing emergency describing what's happening now, not where there's not an emergency describing what happened in the past, where it is the information is being provided to deal with what's happening now to prevent an emergency, as opposed to what's provided later as part of an investigation to help build a case or a prosecution. So if it's building a case or a prosecution after the fact where there's not an emergency, that's testimonial. If it is information provided in the moment for the purposes of addressing an emergency, then that is non-testimonial. And if it is non-testimonial, the Confrontation Clause does not apply. So in this case, they're talking about this woman calling 911, alleging domestic violence ongoing, come pick up my boyfriend, he's abusing me right now. That was determined to be non-testimonial, which means the Confrontation Clause does not apply. That hearsay statement can come in without the right to cross-examine that person. So that is a non-testimonial statement for the purposes of Crawford. If you've got questions about this issue or other constitutional issues related to criminal prosecution or other issues under Oklahoma law, you're not going to just want to take information from a video. You're going to want to talk privately, confidentially with an attorney about your specific circumstances. To get that scheduled with an attorney at my office, you go online to makelawEasy.com.